Our big topic, though, is really talking about trusts, what they are, what they do, and just kind of under the auspice of before, everybody thought that everybody had to be a millionaire to have a trust. And a lot of that stems from the way that the tax code used to work. And so, whenever we start talking about trusts and trust fund kids, we often think about people with buku money. And we're going to talk today about how, yes, that still applies, but how there's different laws and different trusts today that even the middle class can utilize to make sure that they're taking advantage of all the opportunities out there. Let's see how we. So I'm Josh Nelson from Nelson Elder Care Law. I'm a elder law attorney, and that's a little bit of a misnomer. I always laugh. I have 6 clients over 100, and 4 of them tell me they aren't elders. So I don't know what age we get old, but I haven't found anybody that's really willing to comment on that one yet. And so the practice of elder law is really focused on sort of estate planning, but with a little bit more emphasis on preserving quality of life, assets, and making sure that whenever somebody has a care need, that they can qualify for all the government benefits that are out there. The big thing that our firm stands for is making sure that we preserve seniors' independence and autonomy, what we call decision making, and then protecting them from what they fear most, which is often becoming a burden on their family or burning through their life savings, especially whenever one spouse is sick and you start seeing how much some of the caregivers cost or the assisted livings or the memory care communities. It gets really scary. And so we help families navigate that to make sure that whenever something happens to one of them or whenever something happens to both of them, that they aren't being a burden to their families and that they aren't just burning through what they spent their whole lives as accumulating as a nest egg. I got into this after doing tax law. That's really where my background started. I have a master's in tax. I love helping people fight the IRS. And my mom, Cindy, started Nelson Elder Care Law. And she was working with a couple of veteran families that had gotten some really bad advice. And I came in and I was talking with them. And I found out that one of the guys was a P 51 pilot. Does anybody know what a P 51 is? It's like the coolest airplane ever from World War II. And so it was the planes that would accompany the bombers to make sure that the enemy aircraft didn't shoot them down. And there were only about 17,000 of these pilots. And I'm sitting there across the table from one of them, just awestruck. And it blew my mind that his son hadn't even heard the story before. He didn't know that his dad was this amazing pilot. And so I really fell in love with helping veterans. And the VA has some amazing programs, but access to them is usually a nightmare to get. And so it was very similar to fighting the IRS and fighting the VA that I got to help great families really go and get what they deserve. And so that's why I do what I do. And I love being able to help you guys and people that are going through the care continuum. Whenever we start talking about our agenda for today, we're going to start with just what is a trust? And the short answer is it's just a contract, it's just an agreement. We'll talk about the different roles involved in a trust. We'll talk about what makes a trust, what makes it legal, what makes it work. Some of the different categories of trusts. Some trusts do different things. Some of them help you avoid probate. Some of them help you qualify for government benefits while you're alive. Sometimes we want to help protect assets while you're alive. Sometimes we want to protect assets whenever you leave. Sometimes we just want to do all those things. And so we'll talk about what that is. And we'll talk about the value of a trust versus a will. We all grow up for most of our lives just thinking that we all need a will. That's something that's kind of ingrained into us as we get older. But there's a lot of things about a will that just don't provide the value that it used to. And that's because a will only controls what goes through probate. And a lot of families find that they do want to skip that. It doesn't mean that you need a trust to do that, but we'll talk about why. The first part that you have is I like to go ahead and assimilate a trust to a treasure box. A trust is just a legal document, so a contract, that spells out the rules to be followed for the property in the trust for the beneficiaries. And I want to be clear here that whenever I say beneficiaries, it could be you while you're alive, or it could be the people you want to give stuff to whenever you pass, or it could be people you want to give stuff to while you're alive. Think of it sort of like a vessel, like a treasure box, that is just something that holds assets. There's a couple different roles in any trust. There's the grantor, which is really just a fancy way of saying the person that created the trust. So, not the lawyer, but the person that had the assets before they go into the treasure chest. Then I'm going to skip over to the right and you see the beneficiary. And I always do that with a car because we're always afraid that people are just going to take everything they get and spend it on a fancy car. But the beneficiary is the person that receives the assets after they come out of the treasure chest or out of the trust. The trust itself is that treasure chest box. And remember, it's just a vessel that holds things. That's all a trust does. And then the trustee is the one that has the key to the treasure chest. So remember, the grantor is the one that has the stuff before it goes into trust. The trustee is the one that can open the trust and put stuff in and out. And the beneficiary is the one that gets to keep the stuff after it comes out of the trust. One person could serve in all of these roles. I could be the one that created my trust as the grantor. I could be the one that has the key to the treasure chest called the trustee. And during my lifetime, I can be the one that gets the stuff whenever it comes out of trust called the beneficiary. I'd also need to have another beneficiary for if something happens to me. But during my lifetime, I could serve in all three of those roles. Whenever we go into a little bit more detail, it's going to be important that we understand what those three roles are. Is that connecting for everyone? Great. There's a couple requirements for a trust. The number one requirement is that it must be in writing. It must have at least one grantor, trustee, and beneficiary. It has to name what the trustee's duties are, what they're required to do, and the grantor, or the person that created the trust, has to have signed the trust. It doesn't require a notary. It doesn't require witnesses in all circumstances. So remember, whenever we talk about a will, it has to have two separate witnesses and a separate notary. With a trust, that's not necessarily required. It does have to be in writing, but by law, it doesn't always have to be notarized. Either the trust has to name a beneficiary of the trust or grant someone the authority to name the beneficiary of the trust. And so if I don't know where I want my stuff to go whenever I pass yet, that's okay. But I have to designate somebody that will make that decision if I die unexpectedly. You'll see back at the very top that one of the requirements is that it's drafted by an attorney. Under Georgia state law, any trust that's going to hold land in Georgia is required to be drafted by an attorney. If you aren't going to put land or your house or something in there, it doesn't have to be drafted by an attorney. Some trusts can just be written out on one-page piece of paper. They don't have to be complicated things, but often they turn out to be pretty thick just because we want to outline all the powers and controls that you're going to give to somebody else or to yourself during your life. There's a couple big categories of trusts, and this is where a lot of people get confused, is that there's one called revocable. You often hear these called living trusts or revocable living trusts. Sometimes you'll see them abbreviated as RLT. In this type of trust, the grantor, the person that owned the stuff before it goes into the trust, can be the trustee, can also be the beneficiary, can change the rules of the trust, and can terminate the trust at any time. There's another type of trust called an irrevocable trust. And a lot of people don't understand what that means because they think that irrevocable means non-changeable. And that is not a synonym here. The only difference between a revocable and an irrevocable trust is that the grantor is not allowed to be the trustee on an irrevocable trust, or if they are the trustee, they can't be empowered to change the rules. What that means is that you can still be the grantor and make changes if you're not the trustee, Or if you are the trustee, you can still act on behalf of the trust, but you have to give up your right to change the beneficiaries later. It doesn't mean that nobody can change the beneficiaries. There's other roles like a trust protector that can always come in and help you. But off of this slide, one of the biggest things I want you guys to gather is that an irrevocable trust does not mean non changeable. It can always be changed during someone's lifetime. If the grantor wants to make changes, they can make the changes. Whenever we start talking about the revocable living trust, remember this is the one where you can be the creator of the trust, the grantor, as well as your own trustee, and you can be your own beneficiary. A lot of times you hear it called living trust. This is because it's created and goes into effect during the grantor's lifetime. Lawyers like to use a lot of Latin phrases, and so often you'll hear this described as inter vivos, which is just a Latin way of saying during the lifetime between living people. I know that it gets confusing whenever we throw those in there. You'll find in estate planning and trust work and elder law, attorneys like to just hide Latin phrases in there. Makes it sound a little fancier than it normally is. But it just means that it was created while you're alive. There are things called testamentary trusts. These are considered revocable trusts, but it's a very scary thing. A lot of times people come into my office and we're looking over what they've had prepared years ago, and it's a will that creates a trust. So, like in your will itself, it will say, if I die, everything to my children in trust, and then it outlines that. This is what's called a testamentary trust because it's created by your last will and testament. It's technically during your lifetime, so it counts as a revocable inter vivos trust, but it doesn't go into effect until the grantor's death. What's scary about this type of trust is you still go through probate. So remember, we hinted at earlier that everything that goes through a will goes through probate. So you know that if your loved one passes, you can't just show up at SunTrust or Truist now with a will and walk out with money. It's got to go through a legal process called probate. And so if the trust doesn't exist except for creation through your will, it's called a testamentary trust. And it still functions as a trust, but you still go through probate to create it. Either one of these two types of trusts becomes an irrevocable trust after the grantor passes. And that's because remember, the big difference between an irrevocable versus a revocable trust isn't the changeability of it as much as whether or not the grantor can make changes. And so if you're dead or the grantor is dead, it becomes irrevocable. The big thing to remember here is that during your lifetime, it uses your social security number for a living trust. So it doesn't affect your taxes in any way. Whenever you pass, what you'll hear about is what's called trust administration. And that's because even if your living trust turns over to an irrevocable trust, it has to get a tax ID number. There's a lot of scammers out there that try and charge you for this. It takes less than 5 minutes and it's free from the IRS. There's no cost to get an EIN number. It literally takes 5 minutes. A lot of times people use revocable trusts to avoid probate. We know that going through probate can be a 6 to 9 month process, even whenever people don't fight. And so a lot of times families want to avoid that. A revocable trust allows for that. So instead of taking 6 to 9 months going through probate, it's a very quick transfer of assets. Your loved ones can literally transfer things the day you die. Most people take about 2 weeks and then everything's wrapped up, which is a lot faster than going through the process of probate. It also reduces any kind of family feuds. A lot of times we find that after somebody passes, the length of time it takes to settle the estate is very, very proportionate to the amount of fighting that goes on. If somebody's doing the right thing and going through probate and they have a sibling that's just questioning what's going on, because it's a confusing process, If the checks aren't getting written fast enough, the siblings start worrying about things that happened back whenever they were little kids. One of the worst ones that we have is literally a family. The dad kept a spreadsheet of every single penny he spent on the two daughters. It was literally split 50-50 down the middle to the cent, except for an old Toyota Camry. And the daughters now, whenever they looked at that spreadsheet, got really upset emotionally because they found out that dad spent more on one wedding than the other. And that was a real point of contention for them. And so they've both spent over $20,000 in legal fees fighting over a Toyota Camry. If you guys know anything about Toyota Camrys, they're great cars, they run forever, but one from the early 2000s isn't worth that much anymore. They made millions of them. And so we really hate to see families degrade into that. And it's just because there's family dynamics, there's emotions that come into play, especially whenever we lose a parent. And so a trust can help avoid that by making sure there's nothing that's going to be held out there that they can fight over. It also works for what's called incapacity planning. And so this means that sometimes in our life, we lose capacity. We could have a stroke, we could have mobility issues that make it so we can't get out of the home or handle our finances. But really, what we're talking about here is cognitive impairment. And so, whenever we go through the stage of life, whenever we aren't able to make our own financial decisions, we need somebody else to be able to help us with those. If the assets are in an inter vivos trust, remember a trust that was created during your lifetime, it's easy to transition over to having your loved one, whether that's your spouse, your child, a caregiver, help manage those things as trustee for you without having to go through the issues of dealing with individual banks and powers of attorney and things like that. It also gives you a lot more privacy. Whenever you go through probate with a will, remember that's a public hearing, it's a public document, it becomes court record, especially if you're going to leave different distributions to different people. Maybe you have different aspects of your life that you want to keep out of the eye of other relatives or family members. You can do that with a trust without ever releasing to anybody else how your stuff goes. This is really important from the perspective that there's a lot of scammers out there. I'm sure you guys, if you ever get caught up at night sick and you're watching TV, you see all these ads for get quick, get rich quick real estate schemes, where one of the tactics they use is going through the probate lists of people that passed recently and trying to buy their houses for pennies on the dollar. So if your kids have their own homes, especially if they live out of state, sometimes they're just trying to move your house into cash as quick as possible whenever you pass. And there's some scammers out there that prey on that list to say, instead of going through the process of updating it or listing it for sale, we'll make you a cash offer somewhere around 60 to 80 cents on the dollar, and you can walk away right now. Unfortunately for your kids, that's still a windfall because they're still walking away with more money than they had. But for you guys, you paid that difference. You're the one that had to make it so that you paid off the whole house. And so we don't want to lose that value. The other advantage of a revocable trust is that you can do what's called dead hand control. And so this is always a great image of, even after you pass, you can still control some of the assets. If you have things that are going to somebody that you want to make sure a grandchild or a child accomplishes things like college or creating their own business or just different milestones in life, you can stretch out money to them. Remember that a will only gives money out in one lump sum. A trust can do it at any time interval that you want. So often, especially if we have kids that are younger or even kids that aren't real great with managing money, a trust can distribute them the money, but up until an age, often 35, 40. We have some people that receive trust funds until they're 65 or 68 and can go on Social Security. It just depends on really how much money we're talking about and what kind of control you want to have. But in a trust, you can stretch it out or put different contingencies that you have to accomplish before you get to receive the inheritance. One of the biggest things that we like to think about here is if we do have second marriages. And so let's say that we have this nice, sweet couple. We're going to call them Don and Dilbert. They've been married for 10 years. They're both 78. After their first marriage, they found love again. They're living a great life. And they both have children from their previous marriages. For the most part, they get along pretty well. They can sit around and have holidays, but their kids aren't necessarily best friends. They each pay a portion of their living expenses, but they keep a lot of their money separate. Each of them has their own retirement plan. And whenever we say retirement plan, we mean like a brokerage account, an IRA, things like that. They aren't necessarily afraid they're going to run out of money, but they are afraid that if something happens to one of them, that their children would be disinherited. And the reason that this is because often, especially after 10 years of a second marriage, we want to be able to support our new spouse if we predecease them, if we die before them. We want them to be taken care of, but we also want that money to go back to our children whenever they pass. And remember that if we go through a will and we just give everything to our new spouse, they don't have to give anything back to our children. And often, if their will just says everything to their children, then their children end up with everything rather than it being split back between both people's children. And so the way that a trust can fix this is by having the money available to the second spouse so that they can use it for whatever we define as support, that they get either a stipend every month or that we take care of the house. A lot of times what we see with this is whenever we have a second marriage, maybe we move into the same house that one spouse owned beforehand, and we want the second spouse to be able to live there with what's called a life estate, which means they get to live there for their whole lives as long as they're able to. But then whenever they pass, it goes back to our own children. And a trust can accomplish all that. The reason they've chosen a revocable living trust is because after the first one passes, a revocable trust becomes irrevocable. They want everything to go to the survivor for the remainder of their life. However, after they've both passed, they want for Dilbert to have his two children receive the 50% that was his. And Dawn, the wife, instead of her children, wants her grandson to receive 40,000 after he graduates from university, and then the rest of it will be split a third to each of her daughters. One of the questions I want to go back to, just make sure that we're all on the same page, is who is the grantor of this revocable living trust? Who had the stuff before it went into trust? Both Dilbert and Don. They're both the grantors. So a grantor can be a couple, it can be multiple people, or it could be an individual. Whenever you have a joint revocable living trust like this, they're both the grantors. But do we see how by having a plan in place, they're able to stretch things out? They put the extra string in there so the grandson gets the 40,000 after he goes to school. And I will say that I'm always a big fan of paying for school after they graduate rather than beforehand. And the reason why is they can get loans and things like that to pay for college, but it's a little bit of a emphasis on them actually graduating. We've all heard stories about whenever parents or grandparents pay for college for children, and then they turn into the 8-year plan for the 4-year degree. Whenever we structure it this way, we can even put time frames on it, like he has to graduate by a certain year or within a certain number of years or even with a certain degree, sort of like a scholarship. And then if for some reason he doesn't do what he needs to do to receive the 40,000, then that gets captured back into the daughters. And so in this case, they have 3 daughters that would split the second 50% from Don just equally between the 3 of them. One of the other things that we want to talk about is just fighting, right? We know that whenever we have somebody that has multiple children, sometimes they don't get along super well. I personally have a sister and 2 other brothers, and we're close, but we don't necessarily agree on everything. If we look at this case study with Albert and Mabel, they've been married for 59 years. I think we have some people on here that might be pretty close to that. You know what an accomplishment that is. I love working with older people just because I always ask them, how'd you meet? how did he ask you, and how long you've been together, and what the secret is. And you get some of the most amazing answers. But so for this scenario, we're going to say they've been together for 59 years. They have one daughter and one son. The two kids have never been super close or agreed on anything. That's pretty common. They get together on holidays or special occasions, but because of the family dynamics, it's not enjoyable. So as the years have gone on, they've stopped getting together. Maybe for Thanksgiving, the son comes over. Maybe for Christmas, the daughter comes over, but it's not as much everybody at the same time. The parents have decided to give up on the fighting just because it's so hard on everybody to have everybody together. And so they've worked it out during their lifetimes where the kids don't have to necessarily be friends. They've seen other families that whenever somebody passes away, the family really segregates themselves even more. The ties of a parent that holds people together is lost. And so they know that their kids aren't going to be very friendly towards each other if something happens to the two of them. And they're scared that that's going to happen to their family. And they're really scared that they're going to end up fighting in court. When does stuff get expensive? Whenever attorneys are involved. When does stuff get really expensive? Whenever two attorneys are involved. And so remember, anytime people are suing each other, there's at least two attorneys involved. And so we're talking about stuff getting really expensive at that point. If Albert and Mabel each have a will and a revocable living trust, the trust can have very specific rules. The trustee can be in charge of taking an inventory of assets, which is just a fancy way of saying, what did mom and dad have whenever they passed? Pay any debts they have, and make any distributions. They can do all that without ever having to go through court, which means that the children will get their share very quickly, often within a couple weeks. We can put in what's called a no contest clause, which means that if the kids come back and start fighting, whichever one causes the most problems or whichever one is trying to sue the other one forfeits their share. So it's a carrot versus a stick here. If you're going to come back and sue your sister or sue your brother, you can actually make it so that they lose their share of the inheritance. We don't like to use these clauses, but sometimes we have to. I'm sure you guys have known, hopefully not in your own family, but in other families, that whenever siblings have feuds, it's a big deal. And it's not hard to imagine how they'd end up in litigation. We can avoid that with a trust by using this kind of clause. All these kind of steps will help reduce the possibility of additional fighting. It makes it so we don't have to worry about them going back and suing each other later. Then we switch modes again and start talking a little bit about irrevocable trusts. And so remember, an irrevocable trust does not mean a non-changeable trust. It just means that the trustee is not the grantor. So we got to have somebody else in there. A big question that pops up is, does it have to be a professional? Absolutely not. It could be a children, a sibling, a friend. It is somebody that you need to trust though. You have oversight to everything they do. And as the grantor, you can always replace your trustee, you can always fire your trustee, and you can always terminate your trust. But it does need to be somebody that you have a lot of faith in. The main types of irrevocable trust that an elder law attorney uses is what's called a VA asset protection trust, which helps people qualify for veterans benefits, especially whenever they need to have a caregiver come into their house or go to an assisted living, or God forbid, they need to go to like skilled nursing care. It can cover that as well. Then there's a Medicaid asset protection trust, which allows for people to protect things like their home, their retirement funds, and their money whenever they get so sick that they need to go for 24-hour care. And so Medicaid is a program that allows for care to be paid for by the state whenever you need around-the-clock nursing care. It doesn't cover assisted livings, but it does cover that $7,000 to $9,000 a month nursing home bill. And then we also use what's called a supplemental needs trust. And we put this into everything that we do, even wills. And the reason for that is, remember that we can do a testamentary trust through your will. The reason that a supplemental needs trust will be added into that is because if something happens to like your children or somebody that's going to inherit from you at work, or a car accident where they're on a government benefit program later on that maybe they aren't on today, maybe they're on disability or what's called SSI, supplemental security income, It's money that the government pays them for their inability to be able to work, but it also provides health insurance for them, as well as a monthly stipend that they use to support themselves. And if you just leave somebody that's on one of those programs an inheritance over $10,000, they actually get kicked off that program and have to reapply once they spend the money down. And so by having this kind of supplemental needs trust language in there, it makes it so that somebody that has a drug problem or a physical or mental disability is able to be supported. So they still get all their government benefits, but can also have this pool of money to help give them a better quality of life as well. The big thing that an irrevocable trust is used for is that you do give a little bit of control up by not being your trustee, but in return for that, you protect your assets from the claims of future creditors. This does include things like credit cards, unsecured debts, Capital One, American Express, stuff like that. But that's not the real purpose of it. The real purpose of it is future medical costs. So if something happens where even if you have good insurance, you need to go to the hospital, you go to the ER, you need some imaging, you have an ambulance ride, those copays add up. And unfortunately, they can add up to a lot depending on what's going on with your medical care. We want to make sure that your spouse and your family doesn't have to pay those bills if something happens to you. Just 2 weeks ago, I had a lady who had an amazing, amazing heart event at home, and she lived up in Blue Ridge. Have you guys been up to Blue Ridge? It's beautiful up there, but one of the problems is there's not a whole lot of quick medical treatment. And so she had to be life flighted, and she got the bill for that life flight. It was $51,000 after insurance. Now, the problem there is if you're needing to be in a life flight, you need it. There's no asking, well, how much does this cost? I think I'll take a regular ambulance, right? You need it, you need it. But because of the way that her trust was structured, she actually will be in a position where she doesn't have to pay that out of her own funds because she doesn't have that money. She only has about $25,000 in a home. And so if somebody's going to come try and take $51,000 from her, that means she would lose her house. And we don't want her to be in that situation. In Georgia, we have a little bit of what's called homestead protection, which means creditors can't just come take your whole house, but it's only up to about $20,000. Where you look at a state like Florida, and it's really, really hard for creditors to ever take your house. But in Georgia, we have to do things to protect our home to make sure that creditors like that can't come take it from us. An irrevocable trust still has the probate avoidance, so you don't have to go through probate. It still has the parts about being able to set strings and fast time frames so that you don't have the family feuds. It still does the privacy and the incapacity planning, and it allows for you to be able to manage assets during your life, but also after death. One of the big things that always comes up with this trust is just because it uses a separate tax ID number, how does that affect me? The type of trust that we use specifically preserves what's called the 121 exclusion. You guys probably don't know what that number is, but you've used it before. What it is whenever you sell your primary residence, you don't have to pay tax on the gains as long as you've lived there for 2 years. It's weird that the IRS would allow us to be able to have an exemption. If you walk outside the grocery store and you find $20 on the parking lot, you're supposed to report that as income on your tax return. Now, I won't call anybody out specifically, it's on the honor system, but we know a lot of people don't. But especially whenever we sell a home and we might have made 20, 30, $100,000 of gain on our primary residence by the time that we bought it to the time that we move, why do we not have to pay tax on that? And that's because of Section 121. And so the IRC is the Internal Revenue Code, and we just call the loopholes, so to speak, by their section number. And this one's called Section 121. For an individual, it saves you up to $250,000, and for a couple, it's actually up to $500,000. So that's why whenever you move, you don't have to pay taxes on your gain. With the type of trust that we use, we can still preserve that for you. In this case study, we're going to talk about Dawson and Daphne. And so Dawson's a sweet older man, but he had a stroke and he needs the nursing home now. We've probably known some people who've gone through this. Super healthy, feel like things are going their way, and then just life throws us a curveball. They have income of about $2,100 a month, which is pretty typical for people that have Social Security income. They have a car that's worth 10,000, a house worth 350,000. Their checking account has about 2,000 in it because they're living off of what they make. They do have an investment account with 235,000 in it. They also have things like clothing, furniture, stuff like that. But for the most part, their net worth is right around 600,000 or $597,000. With Dawson needing to go into the nursing home, the income of $2,100 a month is going to actually be exempt. They don't have to pay anything to the nursing home. The spouse, Daphne, is going to be able to keep that entire $2,100 a month. There's also some exempt assets for Medicaid. So, like the car is exempt, the house is exempt because it's less than the 575,000. Dawson's checking account with 2,000 is exempt. Daphne's liquid assets are allowed to be 129,000, and they're allowed to have some burial savings for 20,000. So they have exempt assets of $511,000. That's huge. But the problem is they had 597,000. And so if we look at that, they have quite the liability there. That means that $84,000 is going to be at risk before they qualify for a program to help pay their bills. That's a huge chunk, right? Think about how long you had to work to be able to actually put $84,000 of assets in the bank. Whenever we go through and do that, if they do nothing, they'd have to spend down that $84,000, or that money is going to go straight to the nursing home. But if they would have planned just a little bit in advance, they could save that entire $84,000 by doing a Medicaid asset protection trust, which would allow for that money to be protected inside that treasure chest so that it doesn't have to go to the nursing home. Often, whenever we talk about Medicaid, and just to kind of be clear if you weren't at the last presentation, Medicare is like health insurance that covers trying to get you better. Medicaid is more like long-term care insurance that covers whenever you have a disability, like after a stroke, if you're not recovering. A state recovery is where the state of Georgia tries to come back after a person passes that was on Medicaid and collect what they spent. And so you'll see in this example, remember that Dawson and Daphne's house was $350,000, and it was exempt for them to qualify. But whenever Dawson passes away, they're going to put a lien on the house for whatever they paid for. So you hear about the state coming, like taking people's houses. It's not that they come and kick Daphne out. That's not the way this works. That would make the front page of the newspaper if the state's coming in and evicting sweet old ladies from their house, right? What they do instead is they put a lien on it, sort of like the same kind of lien you have whenever you have a mortgage, that makes it so that you can't sell it without paying them back. If you do need to move while Daphne's still alive, the state gets paid back. If it goes through probate or it goes through to the kids eventually, the kids have to pay back the state too. If the house was in trust, it avoids that. So often you hear about, if you have an asset protection trust, you need to do it 5 years in advance. And that's because back in the early 2000s, Medicaid had this issue where people would come see an attorney that had millions of dollars, and we'd move money around, and then they'd qualify the next month. And so Congress added a 60-month look back period to the Medicaid requirements, which means if you've gifted or transferred away any assets in the last 5 years, there's a penalty. It doesn't mean that if you're within 5 years of needing this level of care, that there's not value in doing this, but we just want to walk through this example. If they would have done their trust 5 years in advance, the house would be protected from the estate recovery. The $235,000 in retirement assets would be protected. Dawson could qualify to go to the nursing home, and Daphne would still get all the income. So remember, in this case, they had $2,100 of income. Daphne would get to keep all of that even whenever Dawson goes to the nursing home. They would have lost nothing, and Dawson would have gotten the same level of care. A lot of times families talk about, well, I don't want to go to a nursing home. I want to be clear, Dawson didn't want to go either. He had the kind of medical condition that happened to him where he couldn't be safely cared for at home or even at the assisted living level. And so whenever we start talking about the nursing homes, there's always a question of, well, is there a difference between Medicaid nursing homes and non-Medicaid nursing homes? The truth is there's three religiously exempt nursing homes in Georgia that don't take Medicaid. They all have a religious exemption. Every other nursing home, all the ones in Cobb, all the ones in Cherokee, all take Medicaid. And so the only difference is whether or not you're paying the $7,000 to $9,000 a month, or whether or not the state's paying that for you.
Josh, we have a question of other limits on how much you can protect.
Yes. Asset wise, it's all about timing. If you do it 5 years in advance, you can protect 100% of the assets. If something happened where Dawson and Daphne had created this trust and it was only 2 years ago before he had his stroke, we know that more than 50% would be protected no matter what. We'd have to look at what his actual care cost was to get the difference. The other thing that we have to keep in mind is that some people have really, really strong pensions. And so sometimes we'll have people that come from like working with the IRS or the GBI, just people that have really, really strong pensions. And if your pension is over $10,000 a month, which means not your IRA distributions, but just your pension is over $10,000 a month, this might not be the tool for you either. We'll have to sit down and talk about that. Sometimes it is, sometimes it isn't. But if you start having income for the couple of over $100,000 a year, $120,000 a year, this might not be the right tool. There's some other tools in the toolbox for that. All trusts aren't the same, just as what we talked about before. There's the two main categories of whether or not we're protecting assets or whether or not we're avoiding probate and fighting. One of the big things you want to make sure your trust has is that it's protecting the beneficiary, like what we talked about with that supplemental needs trust language. So even though everybody's healthy and doing well right now, there's some things that can happen to people in life where we wouldn't want to give them an inheritance right away. Maybe that's something where they have creditors, they're going through a divorce. If you've ever had a child go through a divorce or you've ever had to go through one yourself, you know that it can really run high with emotions and people are fighting a lot. And you don't want for your passing to inflate your child's share that just goes to your ex-in-law then. And so a trust can prevent that from happening. If it's going to skip your children and go to grandchildren because you've had a child that predeceases you or that's just part of your plan, we can set limits on what age they receive things. So instead of getting a big lump sum at 18, as a firm, we usually don't give money to anybody under 25 without supervision. And for a lot of families, we've been asked to do it as 30 or 35 or even older. Whenever you see the word spendthrift, that's one of my favorite parts of trust, and it's something that most people don't understand. What it is a fancy way of saying that if we're going to give money to somebody out of a trust, we can put a paragraph in there that says that if they have creditors, if somebody's suing them, if they owe money because of a business failure or a car accident, whatever the reason may be, we can actually keep that money from going to their creditors so that what you guys worked so hard for doesn't just go to the creditors of your children. We also want to make sure that we maintain homestead property tax exemptions. So you guys know once you start hitting 62 or 67, depending on your county, you actually save quite a bit in property taxes. If you just got a savings of 2,000 plus a year by not paying school tax, you don't want to put your house into a trust that doesn't have homestead exemption language in it because you'll lose that. And the property tax assessors are super powerful whenever it comes to enforcing those because they don't really like giving out those kind of discounts. We also want to make sure there's language in there to protect your trustee. Most people that we work with don't have a professional trustee. A professional trustee charges usually at least $10,000 a year to act as a trustee, and they usually get a percentage of about 1.75% of the trust assets too. Most people that have less than a million and a five, there's no way that that would work for them. If you have somebody that you trust, like a child, a sibling, that's usually a better answer for the type of trust we're talking about. The old professional trustee model really is set up for millionaires or multimillionaires. It's for people that have 5 million, 10 million sitting in their trust that's kicking off enough income to pay for that. Most of the families that we work with have less than $400,000, including the value of their house. They're usually under $1,300,000. And if you look at that trust, it can't afford to pay a professional trustee $10,000 or so in order to be able to manage it. For the type of trust that we do, whether it's revocable or irrevocable, the trustee themselves shouldn't be spending more than about an hour and a half per year doing anything for your trust. And because there's not that much time involved in it, sometimes we give them a little stipend, but for the most time, we just say they're going to do it out of the goodness of their heart because you raised them right and they want to help you out. Just as a quick little refresher here, we want to talk about the roles of the trust again. This is really important because we call them the different things, we got to focus on what the differences are. And so remember, the grantor is just the fancy way of saying it's the person that created the trust or had the assets before it goes into the treasure chest of the trust. The trustee is the one that holds the key, and the beneficiary is the one that receives it whenever it comes out the treasure chest. And so if you have a revocable living trust, remember you can serve as all the three roles: the grantor, the trustee, and the beneficiary. If you have an asset protection trust, you can still be the grantor, but you give somebody else the key to the treasure chest. It doesn't mean that it can't be opened. It means that you have to go through somebody else to do that. But as the grantor, if that person ever doesn't follow your wishes, you can replace them, go around them, or fire them. And then you could be the beneficiary on both a revocable living trust or an irrevocable trust, both during your lifetime. And then you have to have somebody as a successor afterwards so that we know where it's going to go. You always want there to be a trustee and you always want there to be a beneficiary, though.
So Josh, on that one, can there be more than one trustee?
Great question. From a legal perspective, absolutely. From a practical perspective, we often find that it's better to have one decision maker whenever we're dealing with finances rather than two. If you have three kids, it's easier than if you just have two kids because there's an easy way to break ties, right? Majority rules. If you only have two kids, the problem is if they disagree and they're both trustee, how do we break a tie? And a lot of the planning that goes into this is to keep us out of the court system. And so you'd have to have a pretty persuasive argument on why you would want two trustees before I would do two if you only have two kids. Whenever you come in to sit down with us, we walk you through all that. A lot of times parents do it to try and be fair, but from a practical perspective, it can also cause problems, especially whenever one lives out of state or one's busier than the other, that it causes more problems than it really solves. And so we'll walk you through that if that's something you want to do. From a legal perspective, it absolutely can. I actually had one yesterday that we did two trustees on just because the kids really get along super well. And mom actually travels, depending on the time of the year,
Message.
where she lives with some of the daughter 6 months of the year and the son 6 months of the year. And so for them, they had a persuasive enough argument on why they wanted two trustees, and we did it that way. But for most people, we're going to do it as what's called successor, which means it's going to be child A is the first one. If something happens to child A, it doesn't mean that they die or that they're sick. Sometimes if they're a caregiver for their spouse or for one of their kids, they just have too much stress going on in their life, they want to give it to a sibling, they can do that. And we set it up so that the successor, they just sign a one-page piece of paper, and it transfers to whoever the next in line is.
Okay, we have another question. In the irrevocable trust, does the trustee have access to the assets, or will the language of the trust decide that?
The language of the trust decides that. The way that it works generally, and again, each scenario is a little different. If the assets that go into the trust are assets that you use income off of to live your life, then that income usually comes to you directly without having to go through the trustee. If the assets that you put in the trust, such as like a home doesn't create value until you actually sell it, then the trustee cannot sell the house without your approval, and there's no income to be distributed, so there's no taxes, there's no money coming back to anybody. If you talk about something like a brokerage account, it has dividends or interest or some kind of income that gets kicked off of it. Often that's going to come back to the grantor or the person that owned the asset first. You can trigger that to other people in certain circumstances, especially whenever we start talking about VA benefits. Sometimes that's a strategy we'll use. The VA benefits that we talk about that help pay for care are very dependent on income. And so sometimes if people have too much income, we'll want to attribute that income to somebody aside to the grantor. But we'd sit down and walk you through that. The trust language can control who actually receives it, though.
Excellent. Are there any other questions?
I
Josh?
was
Oh,
I was typing, and I'm not fast, and I misspell a lot. Can I just ask here?
sure, absolutely.
Okay. It's my understanding that the only things, assets that you can put in a trust are those things that are solely owned by you or me, if it's me.
Okay.
In other words, if there's property or accounts or whatever that are jointly owned, then they cannot be placed in a trust.
They can still be put into a trust. A big question that comes up with this is often with like land. And so inherited property from grandparents or parents or just land that's been in family for generations gets diluted really fast, right? So if whenever your great grandfather passed, he left everything to his kids and then they left it to their kids, it's common for people to have like a 1/14th share ownership in a farm that's maybe in like Louisiana or Alabama or even South Georgia. You can transfer whatever you own of that property into the trust the same way that you can transfer anything you own. The only restriction on that, especially with family farmland, is that often that farmland is in a trust that has restrictions on you transferring it. So if the trust itself that owns the farm says that you have to give what's called like a first right of refusal to your cousins before you transfer or sell it, sometimes that covenant can keep you from transferring it. But just because you own something jointly with somebody else doesn't mean that you can't transfer your ownership in it to a trust. So if you have, we run into this a
So,
lot where like a parent would put their two kids on their house. It's very, very bad thing to do tax wise because you lose that 121 exemption that we talked about. But you could still transfer your ownership of that into the trust.
so joint checking accounts, cars, um, the house that you live in.
Yeah. So the house you live in, absolutely. The joint checking account, it's about whether or not we would transfer the account itself or possibly just the funds in the account. We'd have to sit down and see exactly what you use that for. I will tell you that at our firm, we don't put vehicles that you drive into the trust. So if you have like a 1950s Porsche, yes, that goes into the trust because it's an investment. But if it's your normal daily driver that you go get groceries with, in Georgia, it's considered an exempt asset from both creditors and probate. So you can transfer it after your passing with just a one-page form. And unfortunately, just like the title of this presentation, where everybody thinks that everybody that owns a trust is a millionaire, if you transfer your car to the trust, the insurance card has the name of your trust on it. And then if you get in a little fender bender, people's neck and back tend to hurt a lot worse than if you just had it in your name. And so we don't want people coming back and suing you thinking that you got buku money just because you tap them at a red light.
So we've got one more question. I want to be mindful of Josh's time because it's 1 o'clock. If you have a revocable trust and everything pours over into the trust and your home is in that trust too, can you still add on the Medicaid Asset Pro?
Absolutely. And so, especially with the revocable trust, it can always be amended or restated at any point in time. And so, if you already have a trust, especially if it's already funded, it's a very easy process to be able to take that and put the protections around it that the asset protection trust offer. The big thing to look at is just making sure that it is actually funded. One of the hardest conversations to have in my line of work is when people have gone through and gotten a trust from somebody else and thought that things were funded into it. And then whenever we look through it, their bank accounts, their house, all that stuff wasn't really put in there. One of the big things that's different for our firm is we actually send somebody to the bank with you to make sure that it gets done right. We actually fill the forms with your financial advisor, your brokerage account out to make sure all that stuff is done. So often in estate planning, especially, people get a trust and they get it back and they have this big sigh of relief. They're stress free now because they got their plan in place. But in there, the attorney had like slipped a letter in that says, okay, here's your stuff. Now go do these 10 things for funding. And a lot of times those things never get done. And so sometimes that stuff still ends up going through probate. So we would just verify that whenever we did it. But other than that, the actual adding the protections of the asset protection to a revocable living trust is very straightforward.
Fantastic. This has been awesome. I can tell everybody, I mean, it's been you very succinct, very on mark. And I would say, as you mentioned when you first started, that we've been working together, you and your mom and Aloha to Aging for years. And your mom actually was on the board for several years as well. And we're so excited about the growth that you've all experienced. And obviously this is so impactful, all this information, because like you said, we all thought it was for those that are millionaires. And the reality is after today, I think we all really realized that we could all use it.
Yeah,
So
yeah.
how do we get in touch with you? And the fee structure, I'm assuming, is different for everybody?
No, it's all really straightforward for us. We do flat rate fees. We don't charge hourly. So the way that it works is you come in for free because you were on a presentation and because you know Don. The complimentary consultation, you come in, sit down with a member of our legal team. It takes about an hour to 90 minutes. So you need to make sure you have some time blocked off. We just talk with you about what you have in place, what you want to make sure you accomplish. At the end of that meeting, we're going to give you a flat rate fee that covers everything so that you know exactly what it costs to work with us and what that entails. And then you sign up. And then there's about 3 to 6 meetings, depending on what all you need to have taken care of. But we really do a great job of holding your hand through the entire process, walking with you, making sure you understand things. As you can see just from this presentation, I know this isn't as fun as the one she did. She always does the fun ones. But it's more dense. It's overwhelming stuff. It's a lot of information. And so we find that breaking it up over 3 to 6 meetings is a lot easier for people to digest. One of my biggest pet peeves is whenever people come in and they have this beautiful trust binder and I ask them, well, why do you have it? And they just have no idea. And so we want to make sure that, we aren't trying to turn you guys into attorneys, but we want to make sure you understand what you have so you understand how it works.
Well, and I think another asset for you is your calm demeanor, Josh. You explain everything just fluidly, and you are very passionate. Both you and your mom are very passionate about what you do, which is such a gift to all of us. So we truly appreciate you taking the time. And
Thank you guys. We appreciate it. I do have to jump off here, but if you have any questions or you want to reach out, definitely give us a call. We're glad to answer anything that you have there. And I appreciate you guys joining in. Again, make sure you support Don and Aloha. It's just an amazing thing that they do for the community.
well, thank you so much, Josh. And just as a reminder, we're going to have this on our YouTube channel. So once that uploads, you will be able to find that later today so that you can actually share this presentation with others.